Kotaboy 32 commented on one of my videos, and he was commenting. It was on Constitution and some case laws that were going on. He was saying, the word creator is lost in today's society, and that's true. It's very true. It's true to the point that these people find themselves in a predicament where maybe they might have broken the law, maybe they didn't break the law, and suddenly they need all the law that they can get hold of to put their life back into a normal frame of mind. You don't need a lot of things until it comes up, and then you wish the heck you had it. It's like going down the road and you have a flat tire and no spare. It's the same thing. When you need it, you need it. Now, some time back, I come across something. We need to eliminate the tyranny of case law. Most Americans assume that rulings and decisions handed down in cases that come before American courts are based on and consistent with the rule of law. It's not so. It's not so. In American courtrooms today, court rulings are not based on real law. Rather, they are based on an imitation system, which is commonly called case law or the case law method. The phony case law method of understanding what law is and where law comes from is taught in virtually every law school in America today. Prior to the 1880s, those who desired to practice law studied under experienced attorneys. Their apprenticeship included both the study of recognized legal scholars such as Blackstone, Locke, as well as practical experience in writing briefs and memorandums and observing their masters in actual practice before the bar. Undergirding that system was a universal understanding that law, like truth, is fixed in certain things because it is part of God's creation. And the principles and precepts of law are found in God's Word in His creative order. But the case law system replaced the wisdom of God's creative order with foolishness of men's evolutionary imaginations. Law students, who of course go on to become lawyers and judges and congressmen, are taught that the source of law is the mind of a judge, which is then changed by the opinion of another judge, and well, you can tune in tomorrow to see what the law might be. That's just what it says. William Blackstone could rightly be called the law professor for our founders, for in his commentaries on the law of England, he concluded the laws of nature, having been dictated by God Himself, is superior to all others and binding over all the globe, in all countries and at all times. Therefore, no human laws are of any valid in contrary to God's law, and no human laws have the authority except as derived from that of a higher law. Our founders clearly established a fixed standard of justice for our land. Now, I'll leave this here for a second. First one that I found on Blackstone. This here is William Blackstone, Long War Against Law. In his office in the Alabama Judiciary Building, Alabama Supreme Court Justice Tom Parker proudly displays a 4-volume 1773 edition of Commentaries on the Law of England, written by William Blackstone, the famous English jurist. Commentaries form the core of American jurisprudence before and after the ratification of the U.S. Constitution. After a 10-year study of our founding era political documents conducted by the University of Houston, political science professor Donald Lutz, Blackstone was the third on the list of the most quoted sources. Only the Bible, representing 34 of cited sources, and political philosopher Charles Montesquieu or something, and higher was Blackstone. Well, Blackstone's books were the foundation to American law when the nation was established. The process of hollowing out Blackstone's influence began almost 150 years ago. How did it happen? The short answer is that Blackstone was rejected because Blackstone's ideas were rooted in Judeo-Christian view of the world. God designed the world to express certain ideas and operate under certain laws, and the theory is called natural law. The influence of Blackstone and other thinkers of a similar vein led to familiar founding sentiments such as the mention of laws of nature and nature's God in the Declaration of Independence. These laws apply to humanity as well. When he created man, he imbued him with free will to conduct himself in all parts of life. He laid down certain immutable laws of human nature. God also gave him the faculty of reason to discover the purpose or the purpose of laws. Human law, therefore, is to be the product of people comprehending God's purpose and fashioning their own regulations of human conduct to reflect the divine will. However, following the end of the Civil War, some influential individuals embraced a new idea, Darwin evolution. The Origin of Species, published by Charles Darwin in 1859. It had a huge impact on the movers and shakers who saw no room in American jurisprudence for Blackstone's God-based view of nature. There was a deliberate effort by the president of the Harvard University, Charles Eliot, to change things, to introduce evolution into the teaching of the law. So he hired Christopher Langdale as dean of Harvard Law School from 1870 to 1895, who changed from using Blackstone's commentaries that had immutable principles in it to a case law approach, which means it was studying the writing of judges. What they were able to do was change the focus of God, who gave immutable principles, to the judge, the man who was writing the law. By changing cases over time, they were able to show an evolution of the law. Throughout the famous article, Holmes makes a complete break from Blackstone in the past. Morality was separated from jurisprudence, human expertise and reason were divorced from natural law, and obviously from nature's God. Absolute truth was denied, and the responsibility for determining the truth was firmly placed in the hands of judges. From that point on, judges began to accrue power in the American political experiment. This guy here says, in my constitutional class at Vanderbilt University, one of the better law schools in the country, we never read the Constitution. We just read what judges said about it. That shouldn't surprise us, as there's no absolute truth in a universal sense, so why should there be any consideration given by judges to the original intent of the architects of the Constitution? And what happened is, judicial activism became common because judges became a law unto themselves. You get where this is going? Case law is what a judge says about it, not what the Constitution says. Case law makes the judge the law. Judicial activism became common because judges became a law unto themselves. I'm going to put this down here so you can see this, because this is a very important aspect of this case law thing. Just read what other judges had said about it. And then, because of the changing of the round, judicial activism becomes common because judges become a law unto themselves. Not the Constitution. They're not using constitutional law, they're using case law. That's where the problem comes in with what's going on in our country. Something that Scalia said. I might have to zoom this in too. Yeah. The Constitution is not a living organism. It is a legal document. And it says what it says, and it doesn't say what it doesn't say. But like I said, this case law stuff, people, that's where they're not going by constitutional law. They're going with some other judge had said about the law. That's a wrong way to go about, you know, straightening up the country. There was a move in the 1970s, early 1980s. Lawyers across the country simultaneously were filing these lawsuits in defense of religious liberties. There was no coordination between them. Now they got a new movement coming up here. You know, they're going to try to get this, go back to the Constitution and Blackstone's way of thinking. Whether they will or whether they won't, I don't know. But like I said, they're not going by the law. They're not going by the Creator. They're not going by natural law. They're going by what another judge said about it, and that judge becomes the law. That's why everything is so messed up. That's why they said here, you know, most rulings. Most Americans assume that the rulings and decisions handled down in cases that come before American courts are based on and consistent with the rule of law. But regrettably, this is not so. I wanted you guys to see this so you understand this a little bit better. In American courtrooms today, court rulings are not based on real law. Rather, they are based on an imitation system, which commonly is called case law or the case law method. Like I said, the judge becomes the law, not the Constitution. Okay, Kotaboy, I hope this helps. This should be still online from Freedom Outpost. Let's see, I'll zoom this in here so you can see. It was by Jake McCauley, December 30th, 2017. Constitutional law, we need to eliminate the tyranny of case law. And this other one that I have here was put out in 2015. I made copies and I sent to a few of the guys. Anyway, thanks for watching. I just wanted you to know that, Kotaboy. That's why they're really not going by the Constitution. They're going by what other judges say. Thanks for watching.